You know, it's often said right about now, last but not least. And sometimes, you know, if we're being honest with each other, you mean that perhaps a little more or a little less, the last but not least. But today, I mean it a lot more. We're very honored to have the FTC chairman here with us as our last speaker, but by no means the least. So even with this new light, I still have to pull out my reading glasses. I'm going to do just a little more than I've done by way of introduction with the other speakers because we're so pleased to have Joseph Simons with us for the first time, but his full bio is in the brochure. Joseph Simons was sworn in as chairman of the Federal Trade Commission on May 1, 2018, just approaching his first anniversary. Before joining the commission, Chairman Simons was a partner at Paul Weiss, Rifkin, Wharton, and Garrison, LLP. You know, in an era where all the law firms seem to have shortened their names down to, for example, Cooley here, that's still a good old-fashioned law firm name. And he was co-chair of the firm's antitrust group. Chairman Simons has had previous stints at the FTC. He was director of the Commission's Bureau of Competition from 2001 to 2003. And prior to that, he served even earlier as at the Bureau of Competition from 1987 to 89 as assistant to the director. I'm going to leave the rest of Joe's bio to you with your, you'll find it in the brochure. So without any further ado, please join me in welcoming Joseph Simons, please.
All right, well, good afternoon, everyone. First of all, the only one who calls me Joseph really is my mother, and she's passed, so nobody really does that anymore. So I go by Joe. And let's see, hopefully I can see up here. Yes, absolutely. All right, so I am absolutely delighted to be here today. Thank you, Randy, and the Free State Foundation for inviting me to speak at this 11th Annual Telecom Policy Conference. The subject matter of many of today's panels, internet policy, telecommunications policy, privacy, and data security, touch on some of the most dynamic areas of our economy. I find these types of discussions very valuable in raising hard questions, challenging our assumptions, and updating our thinking. Indeed, at the FTC, we are also thinking through some of these very same questions in our hearings on competition and consumer protection in the 21st century. Part of what we're doing is engaging in self-reflection to see how we can use our existing antitrust and consumer protection enforcement tools most effectively to target conduct in these rapidly changing areas. Today I'm going to talk about how the FTC's two missions, competition and consumer protection, apply to the internet ecosystem. Recent important developments make this topic particularly timely. First, in 2018, as you guys have been talking about probably for most of the morning, the FCC repealed the Open Internet Order and passed the Restoring Internet Freedom Order. The 2018 order repealed the Open Internet Order's classification of broadband internet service as a telecommunications service, which is considered subject to treatment as a common carrier. Everyone here knows all of this already. The FTC Act contains an exception, however, for common carriers. And so by returning broadband to its original classification as an information service, the 2018 order returned antitrust and consumer protection jurisdiction to the FTC, for which we were very grateful. A second recent development in FTC versus AT&T Mobility, the Ninth Circuit recognized in an en banc decision that common carriers may be subject to the FTC's enforcement for non-common carrier activities. This decision, combined with the Restoring Internet Freedom Order, makes it clear the FTC has the authority to protect consumers when internet service providers engage in non-common carrier behavior, such as cable service or video service. So in light of these developments, there's been much discussion about the FTC's role in overseeing ISP conduct. As part of those discussions, it is important to understand the different roles that the FTC and the FCC play in telecommunications markets. To be clear, the FTC and the FCC are very different in our mandates and in our legal authority. The FTC is pretty much a law enforcement agency. The FCC is pretty much a regulator, a sectoral regulator. As a law enforcement agency, Congress has charged the FTC with investigating and, when warranted, bringing cases for violations of the FTC Act, which covers both antitrust and consumer protection law. Specifically, we have authority under Section 5 of the FTC Act to sue ISPs and others for allegedly anti-competitive conduct or unfair or deceptive practices. We're using this authority aggressively to address violations of the laws we enforce, but there are key differences between conduct that are prohibited by the FCC's Open Internet Order and the conduct that the FTC can now reach with our antitrust and consumer protection jurisdiction. First, consider ISP behavior that the FTC may address under the antitrust laws. Antitrust is a very flexible and dynamic tool and covers a wide range of activities. However, the law is limited to prohibiting conduct that is anti-competitive, not simply perceived to be unjust, unfair, or discriminatory, or against a general type of standard such as the public interest. In the Open Internet Order, the FCC prohibited certain ISP behavior, principally blocking, throttling, and paid prioritization on what was essentially a per se basis. Now some conduct such as horizontal agreements between ISPs to fix prices, divide markets, or allocate customers, those would be per se violations of the antitrust laws. And that's because these types of agreements are so manifestly anti-competitive that the antitrust law has determined that they are illegal without looking into what their effect is on prices, quantity, innovation, or competition more broadly. But blocking, throttling, or paid prioritization would not be per se antitrust violations. Paid prioritization is a type of price discrimination, which is ubiquitous in the economy. For example, think about when you walk into a grocery store and you see who else is shopping there. Some of those customers may get lower prices because they've clipped coupons. That's price discrimination. Others might get a senior discount. Again, price discrimination. Others might get 2% off their purchases because they have a particular credit card. Others might get 1% off their purchases because they have a particular credit card. And yet others may get discounts because they have a loyalty card that's issued by that supermarket. These are all forms of price discrimination. Those of us who go to the movies in the afternoon to see the matinees will generally pay less. And those of us willing to show up at a restaurant before 6 p.m., and the older I get, the more willing I am to do that, get the benefit of a lower priced menu. And of course, here's a little audience participation. What's the primary discount that we're all thinking about in this room as the long day of seminar and conference comes to an end? Yes, got it. There's the happy hour discount. That also is price discrimination. And for those of you who live locally, you're a sharp audience. For those of you who live locally, yeah, there you go. For those of you who live locally, think about the express toll lanes on Interstate 95 or 66. Or think about Amtrak's Acela service to New York, which is faster and more expensive than the local trains. So clearly our transportation authorities think that allowing people to pay more for faster service is at least sometimes beneficial. Now, of course, not all ISP conduct, including paid prioritization, is benign or pro-competitive. Some may very well be anti-competitive. Where an ISP excludes certain content, applications, or services, we at the FTC would engage in a fact-specific analysis to see whether that foreclosure harmed competition through raising rivals' costs or excluding competitors. Likewise, our consumer protection mission also may bear on ISP's data transmission activities. Under Section 5 of the FTC Act, we can prosecute unfair or deceptive acts or practices. With respect to deceptive practice, we are concerned about conduct that is likely to mislead reasonable consumers. Our deception authority also focuses on acts or practices that are material, meaning that they are likely to affect consumer behavior, such as purchases or use decisions. Simply stated, we have a strong interest in ensuring that companies stand by their promises to consumers. This is how we have applied our authority over a long period of time and in a variety of ways, and we would review ISP activity in the same way. For example, we could take action against ISPs if they block applications without adequately disclosing those practices or mislead consumers about what applications they block or how. Our Consumer Protection Authority could also apply to throttling. To determine whether a particular instances of throttling are deceptive, we would first evaluate what claims the ISP made relative to the throttling and how those claims are supported. We would look closely at any relevant study and evaluate the study's design, scope, and results, and consider how a study relates to a particular claim that the ISP makes to make sure it's substantiated. To evaluate whether a practice was unfair, we would consider whether the alleged throttling had countervailing benefits, whether there were reasonable steps consumers could take to avoid it, and we would also consider consumer injury, the number of consumers affected, and the need to prevent future misconduct. We've challenged throttling practices before, prior to the FCC's 2015 Open Internet Order. We charged prepaid mobile service provider TracFone Wireless with deceptive advertising for promising consumers unlimited data, but not disclosing that it was slowed down their service by between 60 to 90% after they exceeded certain data limits. The company agreed to pay $40 million in a consumer redress settlement for those charges. We are still litigating charges that AT&T Mobility promised consumers unlimited data, but then reduced speeds in some instances by nearly 90% against consumers who had purchased what they thought were unlimited data plans. We believe this conduct was both deceptive and unfair, and that it harmed consumers. We can also challenge deceptive and unfair privacy and security practices by ISPs. For example, in one action against an ISP, the FTC alleged the company caused substantial consumer injury when it distributed spam, child pornography, malware, and other electronic content. And we brought 2 cases against ISPs under the Fair Credit Reporting Act, alleging that they imposed less favorable terms on consumers who had negative information on their credit reports without providing required notices under the law. In these cases, we obtained a $1.9 million fine against Time Warner Cable and a $2.9 million fine against Sprint. Despite the fact that we are using all of our tools that Congress has given us, I note that we certainly could use additional authority in the privacy and data security area. In fact, I've already urged Congress to enact legislation that would give the FTC 3 tools: the authority to seek civil penalties for initial privacy and data security violations, which would create a much more effective and important deterrent effect; 2, targeted APA rulemaking authority that would allow the FTC to keep up with technological developments; and 3, jurisdiction over nonprofits and common carriers. The process that the Congress is now going through, one of hashing out what may become federal privacy legislation, is a difficult one. It involves the consideration of difficult cultural and societal values and trade-offs along the way. And we've suggested to Congress that they are the ones who are most qualified and positioned to make those trade-offs, and that it's not an independent agency which has unelected officials in it. It's not, we're not best positioned to do that. That is something for the Congress to do. But regardless of what the Congress chooses to enact, we at the FTC commit to using our extensive experience and expertise in this area to enforce any new legislation vigorously and enthusiastically. In addition to our enforcement work, we engage in research and policymaking efforts to keep up with privacy developments affecting ISPs. Just recently, I think it was today actually, we announced that we're using our authority under Section 6B of the FTC Act to study the privacy practices of ISPs. We've issued orders to 7 companies seeking information about their privacy policies, their practices, and their procedures. In particular, we ask questions about how the ISPs are collecting, using, combining, and disclosing the personal information that they collect about consumers from sources such as providers of fixed and mobile internet, advertising platforms, and analytics services. The Commission is actively strengthening its existing expertise in broadband and tech markets, and we remain vigilant in reviewing conduct in this space. On February 26, we launched the Technology Task Force, a team of antitrust attorneys and a technology fellow charged with monitoring competition in U.S. technology markets, including the internet ecosystem. Just last week, we held a hearing on competition and consumer protection issues in broadband markets. The hearing focused on 3 main topics. What is the current state of broadband markets and technology? How can the FTC best identify market behavior that may violate the FTC Act? And once behavior is identified, how can we best use our enforcement authority to deal with it? I'm going to end my formal remarks by emphasizing that the FTC will remain very active in internet commerce. Although our statutory framework differs from the 2015 Open Internet Order, we will be able to protect consumers from anti-competitive and unfair deceptive conduct by ISPs or other firms in this fast-paced industry. Thank you again, Randy, for inviting me, and I'm happy to try and answer some of your questions.
Well, you can see how important it was at this conference to have the FTC chairman with us in light of everything we've been talking about today with ISPs and internet platforms. Joe, may I call you Joe? Just,
yeah, please,
yes.
Joe.
There were a lot of takeaways from that speech. Just 2 things quickly that I want to mention. When Joe was referring to various types of discounts that occur every day, I know that probably rang a lot of bells with us, but I was wondering why when he mentioned clipping coupons, he was looking directly at my wife over there.
That was by accident.
It was? Okay, that makes me feel bad.
But if my wife had been in the audience, I definitely would have looked at her.
One of the world's most proficient coupon clippers. But more importantly than that, I think you can't but walk away with an understanding, really, of the extent to which the FTC is, to use that phrase, quote, the cop on the beat for so much of what's going on now in the internet ecosystem and with ISPs, which he spoke to. So with that, we're going to take a couple of questions. The chairman will, and then no one get up before I have a chance to close out the conference after that. We should, normally I call on, someone raise your hand. Well, we'll ask Commissioner Rob McDowell first question.
That was quick. Mr. Chairman, thank you, first of all, for coming here today. Just wanted to let you know that Alden Abbott did a fantastic job earlier on the panel. Remember, I told you I'd give you a shout-out, Alden. So,
I would expect nothing less.
He's not going to let you forget
nothing
this.
but the best from Alden.
Yeah, he's excellent. So I thought, so your agency did come out with the 6B orders against the wireless companies today regarding privacy. I thought I'd give you a chance to sort of expand upon that, and then maybe with the added degree of difficulty of is there an effort at the FTC to try to harmonize across industries and platforms privacy enforcement? But do you want to talk more about the 6B investigations?
Sure. So the 6B is part of a much broader effort. I've seen some tweets and other things suggesting, oh, we have to do much more, but we are going to do much more. So in addition to this first shot out of the box with the 6Bs, we also have the Technology Task Force that I mentioned a few seconds ago, and we'll have investigations, and we have investigations. So it's a full range of things. It's everything from 6B to hearings to workshops to investigations and potentially enforcement actions.
Another question? Barron? got to be a question now, not a statement.
Well, all the introductions here are very short, so I'll keep mine short too. So, Commissioner Simons, I'm curious to know about your call for civil penalty authority on privacy.
Sure.
Are you proposing that as across the board, or would it be limited to specific rules? Because the basic approach in the FTC Act and that Congress has always taken is that civil penalties are appropriate when a regulated party can reasonably anticipate what its conduct has to be. And so when there's a rule or a consent decree, that's appropriate. In extreme cases, like where there's fraud, that's appropriate, but not where there's a broad standard like unfairness and deception. And privacy law, unfortunately, is going to inevitably have a lot of that in it, like respect for context and risk, to me, are no different from unfairness and deception. And I don't know how a regulated party can reasonably anticipate and have constitutionally fair notice under the Due Process Clause of what it's supposed to do under those standards. So would you include those in the scope of civil penalty authority?
Sure. So what we're hoping is that the Congress will enact something that's very specific. The thing we don't want Congress to do is to enact something that's very broad and vague and tell the FTC, hey, you figure it out. If that's what we did, those kinds of, if that's what happened, those types of concerns that you raised, I think would be very, very appropriate. But what we're hoping happens is something much more targeted. And then we'll have our own, hopefully, our own rulemaking authority. The genesis behind this effort to seek civil penalty authority is both with respect to data security and privacy issues. Our ability to show any kind of material degree of harm is very difficult. And if you think about data breaches, for example, particularly nowadays, there's been so many data breaches that when you have a new one, it's pretty hard to tie the data breach to any particular harm, any particular identity theft. And so you're in a situation where, without any kind of serious monetary redress, it's very hard to create the proper deterrent effect. And the same type of issue crops up with respect to privacy as well. It's hard to have a penalty large enough under our current authority to create a large enough deterrent effect.
Do we have one more question? We'll take one more up front here. Kathy, up here.
Hi, Ashley Gold here. Wondering if you have any reaction to Senator Elizabeth Warren's call for breaking up tech giants and mixing up the whole tech industry a few weeks ago. Do you have any reaction to her plan she rolled out?
Is there something specific about it you want me to answer?
Is there anything in it that you think the FTC currently doesn't have the authority to do or strikes you as a particularly bad idea?
I guess I would say we're still studying it, so I don't really have a view.
You see, we always end up with a tough question here at the Free State
Yeah.
Foundation. Stay,
Thank you.
don't leave, right?
Okay.
You a second. Okay. So in just a moment, well, I'll do it. I'll go ahead and do it right now so I don't forget. I want to give Chairman Simons just a small token of our appreciation. That's the way we've been putting it. Everyone that's preceded you, all the government officials, seem to have agreed that whatever in the heck the guidelines are at their agencies, this little bag fit within them. So I hope it does. It's useful immediately. Now, if you were here at the beginning, and I know you weren't, but I said at the outset, Chairman Simons, that each year, this is our 11th annual conference, each conference has been better, in my view, than the previous conference. And no one disputed that this morning at all. In my view, again, I feel it's pretty safe to say that this conference, and look at the audience that's still here, to your credit, that this 11th annual conference has been, I think, our best ever. I know when I open the 12th, I'm going to say the same thing as I always do, but I hope you'll join me in thanking Chairman Simons for being here, and also I thank you for attending this conference. Thank you.